Hi, everyone. It's Attorney Aaron from Indiana. I have a new video for you today. Hope you're having a great Friday. Let's get started.
Is this Mr. Wright?
It is, Your Honor.
Okay. Up next, we have people in the state of Michigan versus Donald Wright, file 22-6356FH. Mr. Wright, we are providing public access both in the courtroom and also online. We have Mr. Wright here with his lawyer, Mr. Gilbert, prosecuting attorney, Ms. Goodrich, and Agent Fagan from the Department of Corrections here for Agent Tuday. And we're here for sentencing on a charge of assault with intent to commit sexual penetration, a 10-year felony. Mr. Gilbert, have you had a chance to review the pre-sentence report with your client?
We have, Your Honor.
Any additions or corrections?
There was just one correction, Your Honor, on the first page of the valuation and plan, the third paragraph down, in describing my client being adopted. It says Dante was adopted. The second sentence of the third paragraph, Dante were adopted by the Wrights. That should be Donald was adopted by the Wrights because Dante is his brother.
Well, it says he and his biological brother, Deontay, were adopted by the Wrights. Did the Wrights adopt them both?
Oh, I misread that, Your Honor. My fault. I misread it when I misread it.
Okay,
That's correct. That is correct.
No worries. The advisory guidelines are at 5 to 23 months. Any scoring challenge?
I did, Your Honor. When I went through that, I wanted to point out that when I went through it, OB4, I didn't think should be scored at 10. I understand that actual treatment is not necessary on OB4 for psychological damage, but I did want to read through the reports. I didn't see whether there had been any claim of that, and so I was questioning OB4, and also I would question the OB8.
That's the asportation.
Yes, transportation. I know that there was a car involved, but I don't necessarily, in my reading of it, think that it was to another place of greater damage, or that the young lady was held longer than it took to commit the offense. So I was questioning OB8. I thought that should be 0.
Thank you. Ms. Goodrich, we'll take them one at a time here. OB4 was scored at 10 points for serious psychological injury. The defense objections that should be scored at 0. Your response to that?
Your Honor, it does talk about, without having the victim have to testify, it does talk about in the agent's description of offense, how she delayed reporting due to her fear as a result of that incident. I think that the description of the offense reflects the psychological trauma that she went through.
Do you know if the victim's intending to make a impact statement today?
She is.
Well, I mean, perhaps based on what's in the pre-sentence report, I would not score it because the fear during the offense does not support that score under the case law, and the probation agent's belief that anybody would have experienced a psychological harm also under the case law does not support the score. If we have a victim here that's making an impact statement, I think we should probably hear that statement before I make a decision whether there's sufficient record evidence for that. So maybe we should go out of order and take the victim impact statement now.
Okay. Your Honor, I'd ask that Alyssa Washington be able to speak.
Judges considering a score that goes to the pre-sentence investigation report as far as what will ultimately what would the defendant's sentence be, how many years incarcerated, and the defense attorney saying, hey, it should be 0. Whoever did the report saying it was 10, and the judge is saying that the information does not support a score of 10. So we need somebody, we need more information. And they say, well, the victim's here, so let's have them testify. So that's what we're doing here now. And I think we'll get a determination after this on what the score shall be.
Okay. All right, go ahead and tell me anything that you wish me to know before I sentence Mr. Wright.
Okay. I would like to say that it strongly impacted the way I live my life every day now. I feel like I can't walk alone at night or anywhere alone without feeling like someone's gonna do something to me. It hurt my mental health badly, and I did hurt myself because of it. And during that, it hurt the people around me as well. And I can't bring myself to walk alone anywhere. And the way I see people before isn't the same way I see them now. Like, I can't hang out with like my guy friends anymore by myself. I don't even trust hanging out with my girlfriends by myself anymore. I don't really trust older family members anymore because of it. And I think he deserves the maximum amount he can get because he is a grown man and I was 15 and he knew better than what he did.
Thank you.
I'm Jessica Burville, her mother. This was really bad, really bad. We spent sleepless nights with that little girl. She'd hurt herself, she cut herself, she tried to commit suicide. She was stealing alcohol. I mean, I didn't even know what to do. It was so bad. I didn't even want to leave her bedside. It was that bad. I made her sleep on the couch so I could hear if she moved to make sure that anytime she needed me, I was there. So I just wanted to make sure that nothing will ever happen to her again. I can't really prevent it, but I will try my hardest to be there for her in anything or something like this. It's not the first time it's happened to her, and it's bad that it happened again. And not by the same person, but it sucks to have to deal with this all over again with her.
Mr. Gerber, any further argument on
Both of those were very difficult for anybody to hear, and it would obviously weigh on the judge's sentence and perception of what a score on any pre-sentence investigation would have on the severity to the victim. It's obviously, to me, that this has been scarred tremendously by this event. Her mom's testimony was more animated, but I think it helped tell the story. It's going to be very difficult for this defendant.
Your Honor, I think that the testimony of the victim establishes that there was psychological harm.
I agree. The victim described how it's impacted her life since the offense. In fact, some self-harm and affecting her relationships with other people, including friends, and broken trust and fearful. So I'll leave OB4 scored at 10 points. Now, in terms of OB8, that is scored at 15 points for asportation, and the defense objects that there's insufficient evidence of that. It should be scored at 0. Ms. Goodrich, your response?
Your Honor, the defendant was driving his vehicle with the victim in it at the time of the sexual assault. They were in the vehicle. I believe that the victim had talked about in the agent's description of the offense how the defendant talked to her about a gun. When she was with him previously, she had seen that he had a gun that was tan in color. And while this time didn't actually see the gun, he was alluding to it, which made her afraid during this and caused some of the fear and delay in reporting later.
Thank you. I would leave the score at 15 points. Not really because of the gun or the fear of that, but under that offense variable, you score 15 points if a victim was escorted to another place of greater danger or to a situation of greater danger or held captive beyond the time necessary to commit the offense. The held captive beyond the time necessary to commit the offense is a closer call. He does say we're not leaving until something happens, but the something is really the assault. But I do think even though she left the house to go hang out with him, she didn't ask to go down to a dead end road at 11 PM at night and be isolated by this defendant. And so I think that is a place of greater danger for the defendant to bring a minor child to a dead end road at night where he can commit a crime against that person. So I'll leave OV 8 scored at 15.
Thank you, Your Honor.
Ms. Goodrich, do you have any scoring challenges?
No, Your Honor.
The court has one. OV 10. Exploitation of a vulnerable victim was scored at 10 points for the offender exploiting a victim's physical disability, mental disability, or youth. I think certainly there's grounds for that and nobody's objected, but I wonder whether it should instead be scored at 15 points for predatory conduct based upon the fact that there was some pre-offense conduct here in that this defendant purchased vapes for this minor that she was not on previous occasions. So he's sort of establishing himself as someone that will provide things for her, and he's manipulating her in that fashion. So I want to hear from both counsel on whether that constitutes predatory conduct as pre-offense conduct directed at a victim for the primary purpose of victimization. Mr. Gilbert.
Well, my position on that would be, Your Honor, that the vapes and the purchase thereof were done independently, and it wasn't. I don't think there is any direct correlation to her then joining up with him and this incident happening. Again, I believe that 10 points should be scored here because of the youth. However, I don't know. I've been reading through it. I did not think that purchasing of that was predatory or grooming or that type thing. As just because he was doing it as a friend would do it or that type of thing, even though she was underage and couldn't do it herself.
Okay, thank you, Ms. Goodrich.
Your Honor, I believe that does meet the definition of the predatory conduct pursuant to MCL 777.403A, the pre-offense conduct as the court described. For the primary purpose of victimization, he did this while luring her to the car. And so I believe that does qualify.
All right, I do think that that's sufficient evidence of pre-offense conduct where he's gaining her trust. He's providing her stuff that she can't otherwise obtain on her own. He's befriending her on social media. He's obtaining vapes for her. You know, he's an adult providing a minor with things that they're not allowed to have. And then, you know, he's leveraging that relationship to end up isolating her and sexually assault her. So I'm going to score OV 10 at 15 points. It doesn't change the ultimate guideline.
Again, here, this is more bad news for the defendant. I like the defense attorney's argument here that this should only be a 10-point offense, that there's no direct correlation with buying the vapes and doing these things. However, the judge sees it a different way and thinks that this was something that was done to lure her in through his actions. So obviously, the judge explained his reasons and scored it at 15.
But it does increase the OV to 70 points, still OV level 5, and a guideline range of 5 to 23. Mr. Gilbert, anything you'd like to say on behalf of your client?
Yes, Your Honor. In this case, and not to minimize at all what had happened or what the victim has gone through, I would like the court to take into consideration. I did ask for forensic in this case because, and none of that has changed with my interviews of Mr. Wright. I told him I was going to say this because it's true. He's very slow and has a very hard time processing things. And after I had to explain the whole procedure, even as this case developed over and over again, and be asked the same question over and over again, it's pretty obvious that cognitively he's not where he should be. I do believe that probably played a major role in this case, and not understanding the consequences of what was happening or how severe the conduct was. So I do ask the court to take that into consideration. And as I said, it's obvious that I've been thinking about that from the beginning due to my request for the forensic. Even though he passed, that there was issues, and I think these issues existed and are part of the reason we're here. Thank you.
Thank you, Mr. Wright. It's not required that you would make a statement, but it is allowed. Is there anything you wish to say or no?
Yes, I would like to formally apologize to the courts, to the victim, her family. I'm sorry that I did that. It was wrong. And upon getting released, whether it's from here or whether I go to prison, I'm looking for guidance and seeking help. And I'll be on.
All right, thank you. Ms. Goodrich, any recommendations from the people?
Yes, thank you, Your Honor. We've discussed what occurred in this case. The defendant is 21 years old with no criminal history. He is unemployed with a high school degree. The recommendation is 23 months to 10 years with credit for 347 days. We did have a sentencing agreement to a county jail cap, thinking 5-year probation due to the defendant's young age, and that the no contact would continue for those 5 years to assist the victim in feeling safe. However, it criticized court's decision.
Thank you. Well, Mr. Wright, you're here for sentencing on assault with intent to commit a sexual penetration. It's a reduced charge from the charge of criminal sexual conduct in the 3rd degree. Now, you confessed to the police before you even entered a plea here. You confessed to the police that you had sex with this underage victim. So your guilt on the CSC 3rd is pretty evident. And the victim describes further, although you didn't confess to this part, that this was a forcible rape. And under the threat or perceived threat of a gun that you had in the car, and she was fearful. Of course, I'm going to sentence you to prison. So it would be my intention to sentence you on the upper end of these guidelines to 23 months in prison to 10 years. That's the most I can do under the guidelines. I don't see a reason to exceed those. And give you credit for 347 days previously served, $68 in state cost, 130 crime victims assessment, $60 DNA fee, $350 in court costs. You're on the sex offender registry, which has already happened. And that would be my sentence, Mr. Wright. Now, that does go beyond what the plea agreement was, which included a sentence agreement for a county cap. So if you wish, you can withdraw your plea, and then you can go to trial on the CSC 3rd. I'm going to give you a minute to talk with your attorney and see if what you want to do, if you want to go forward with the sentence I announced, whether you wish to withdraw your plea or whether you wish more time to think about it. So let's give you a minute, Mr.
Your Honor,
Yeah.
would the court consider possibly?
I'm sorry. Yes, go ahead.
Would the court consider possibly maybe adjourning the sentencing? Because we know this would give me an opportunity to sit down with them.
Well, let me talk.
Okay.
I want you to talk to him first. Maybe you know. And Mr. Gilbert, you've had some time to talk to Mr. Wright. Do you need some more time to go over
If
his
I could, Your
options?
Honor.
Well, Mr. Wright, it's a big decision with a lot of factors, so I will go ahead and continue this sentencing then to May 9th at 3 p.m. And at that time, you can advise the court whether you wish to go forward with the sentence as I've announced, or whether you wish to withdraw your plea and go to trial.
If you don't understand.
Mr. Wright, I don't want you to make a decision right now that you regret in 5 minutes or 5 days or 5 months. I want you to take some time to think about it. So we'll come back on May 9th and give you time to talk to Mr. Gilbert more about it. Okay.
So maybe it's credit. Just because you want another or losing what you 23 months. So it doesn't hurt you.
Yeah, waiting to May 9th doesn't increase by a single day how long you're gonna be behind bars. So let's just give you time to think about that and talk to the lawyer. Okay.
Thank you very much, Your Honor.
Right, next I see.
Here, the judge has given him a sentence that is more severe than the agreed plea, so that he has the opportunity to withdraw his plea and go back to the drawing board or take it to trial. So, judge is setting a date out here to give the attorney and the defendant time to talk about this and decide what he wants to do. A tough situation. Have a great day.